Good day, Crime Talk aficionados. We have a great show for you today. First, a convicted baby killer gets his execution stayed because the Texas state legislature sent him a subpoena so he could come testify. And guess what? That interfered with his execution date. The Delphi murder case is underway. Apparently, opening statements have begun. Of course, we wouldn't know because it's not televised. The search in the landfill of the missing mom has ended. Let's talk about the pending Kohberger motions. And the grand jury indicts a school shooter and his dad. Another celebrity arrested for a DUI. Karen Reed is speaking to the press, which is odd since she didn't testify at her own trial. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below, and make sure that you hit that bell so that you receive notifications of when we go live or put up new content. Now, it is Friday, October 18th, obviously the start of the weekend. We hope you have a great weekend. Well, let me tell you this. It's the weekend. You're going to meet new people. People are going to come into your life. And before you let them come into your life, you need to check them out. All right? If you're dating somebody and you meet them online, it is dating malpractice, ladies and gentlemen, if you don't check them out. So go to crimetalksearch.com, sign up for that background subscription service today. And when you do, you will be able to do a background search on that particular individual. And while you have that subscription, which you can cancel at any time, you can do an unlimited number of searches on anybody that's coming into your life, or maybe people you're just curious about. All right? So when you do the search, you're literally going to get a report done while you wait, and it's going to have information about somebody's addresses, where they work, where they've gone to school, possible usernames as it relates to social media, email accounts that are associated with you, possible assets, their criminal history. Do they have bankruptcies? Do they have liens or judgments against them? And are they on one of those, public registries that we all hear about? Go to crimetalksearch.com. Check them out. All right, let's go ahead and get to the docket, and let's open the record for October 18th. And first on the docket, as I mentioned, the convicted baby killer gets his execution stayed because the legislature subpoenaed him to appear at the State House. So this guy, Roberson, was convicted of killing his 2-year-old daughter, Nikki Curtis, who was diagnosed with shaken baby syndrome. But there's been experts and some lawmakers, and even the lead detective in the young girl's case, say that the science supporting Roberson's death sentence, well, it really just doesn't hold up, and that it is frankly just junk science. Now, the state's highest civil court said that it wants a lower court to resolve a separations of power issue raised by the group of Texas lawmakers who subpoenaed the death row inmate the night before he was set to be put to death. So the Texas Supreme Court late Thursday halted the execution of Roberson hours after it was set to take place, stopping a flurry of litigation filed the same day by the Texas state lawmakers in a last-ditch attempt to stop the state from killing the death row inmate who they believe is innocent. The unprecedented step sought to give the man a final lifeline after a series of court rejections left him on track to become the first person in the country executed for allegedly shaking a baby to death. So along with the stay, the Texas Supreme Court ordered a lower court to resolve the separation of powers issues, which halted Roberson's execution in the meantime. It's not immediately clear what legal recourse Roberson still had to vacate his execution despite the stay, and the courts have rejected all of his appeals thus far. So for over 20 years, Robert Roberson has spent 23.5 hours a day, every single day in solitary confinement in a cell no bigger than the closet of most Texans, according to the Texas lawmakers. And they want to welcome Mr. Roberson to the Texas Capitol, along with 31 million Texans finally giving him a chance to be heard, is their position. So after being told about the stay, apparently Roberson was great, praise God, and thanked all of his supporters. So then early Thursday, the Texas Court of Criminal Appeals had cleared the way for the execution to proceed, overruling a Travis County judge who hours earlier said the state can't execute Roberson if doing so prevents him from complying with the legislative subpoena. You know, you can't be two places at once, ladies and gentlemen. And so the Texas House Committee on the Criminal Jurisprudence then asked the Texas Supreme Court late Thursday to enter a stay, block the execution, arguing that the Criminal Court of Appeals didn't have jurisdiction over the subpoena because it was a civil matter, because the criminal courts only handle criminal cases. So then the issue becomes whether the legislature can actually use their authority to compel the attendance of Roberson, the witness, to block the execution that the executive branch has the authority to enforce, i.e. the death row sentence. It's unclear. And so the Supreme Court wrote an opinion saying the question implicates the distribution of authority among the three branches of government, pitting the two branches against each other. These questions implicate the separations of power at the highest level. Now, what's also interesting to note is the United States Supreme Court on Thursday also declined to stop the execution, though Justice Sonia Sotomayor urged Governor Abbott to issue a 30-day reprieve. Abbott has remained silent on the case. Now, the Texas House Criminal Jurisprudence Committee subpoena requires Roberson's to appear for testimony at the committee on October 21st, which is set to conflict with his other legal obligations, the death penalty. So the question is to execute Roberson or have him present for the hearing. Apparently, this is a big deal. Anyway, the separation of powers issues is set to be resolved by the Travis County District Court, and no one is aware of anyone subpoenaing a death row inmate before to pump the brakes on an execution. Although it does show that the lawmakers have learned about this case, and they feel that this is a strong case involving an injustice. But let's not forget, the state parole board's 6 members voted unanimously earlier Wednesday to deny Roberson's clemency application, as lawmakers raised concern that the courts were not properly implementing a groundbreaking 2013 junk science law that was intended to provide justice to people convicted based upon scientific evidence that has since changed or been completely debunked. The parole board has recommended clemency in just one capital case out of the 85 applications it has considered over the past decades, and it's not shocking that the criminal justice system has failed Mr. Roberson so badly. According to his supporters, what's shocking, according to them, is that the system has been unable to correct itself. So on Wednesday, the Texas House Criminal Jurisprudence Committee hearing raised awareness of Roberson's case and the junk science law, and critics have argued that in the decades since the bill became law, it has rarely provided justice as intended to wrongfully convicted individuals. So there you have it, ladies and gentlemen. I've never seen this before, and I've never seen it, how do I say this, where the legislature has got involved execution, which they have no authority to stop, because it is a separations of power, right? You got the courts, the legislature, and the executive branch, and the executive branch is the one that is required to carry out the sentence that the court has imposed. And there's also administrative remedies, i.e. the parole board, to get clemency as well. And they've rejected that. The United States Supreme Court has rejected it. And so it is a last-minute maneuver, so to speak. And so even if the court were to say there really isn't an issue here because the execution was set first, what would prevent the legislature from then subpoenaing Mr. Roberson back every time there is, in fact, another court date for his execution? So the issue then becomes, if the trial court declares that there is a separations of power issue and that the legislature can bring Mr. Roberson in every time a new execution date is set, we'll never get the execution done. Interesting issue. Now, conflicting writs happen all the time. If you have a client coming in from the Department of Corrections and they don't show up for court, or they honor it in another court, you just have to kind of reset it. But eventually you're going to get the person there. I really don't see how this is an issue. I think that the execution is going to take priority over a subpoena. I just don't see how they can actually say that that's not the issue. I don't know. We'll have to wait and see. Robert Roberson is becoming quite the cause celeb. A lot of people want his execution stopped, but the legal system has spoken. I guess we'll wait and see. Next, Delphi. That's right. Opening statements are underway this morning in the long-awaited trial of the man accused of killing 2 teens in Delphi, Indiana, nearly 8 years ago. That's right. The trial of Richard Allen, accused of killing Liberty Libby German and Abigail Abby Williams in February of 2017 after allegedly luring them to their deaths while they were on a hike not far from their house. Now, their deaths has gone unsolved for more than 5 years when Allen, who was working as a pharmacy tech, was arrested in this case. Now, the trial of Allen, who is charged with the 4 counts of murder in connection with that killing, opening arguments were supposed to start this morning. Now, I don't have personal confirmation of that because, well, we can't watch it because the judge has denied us access to it because she thinks we're all stupid and we just can't handle seeing the facts. Anyway, with jury selection complete, the jurors selected in Allen County were then transported to Carroll County, and they will be sequestered for up to a month. Now, Judge Francis C. Gull, the special judge appointed to hear this case, heard from both the prosecution and the defense on some outstanding issues prior to the opening statements beginning. One motion from the defense sought to have the jurors taken to the crime scene so they could get a firsthand look at the layout of the Freedom Bridge, the Monon High Bridge, and the former building standing nearby. Anyway, the defense withdrew that request on Thursday, meaning that the judge didn't have to resolve that issue. In its original motion, the defense argued that such a trip would give a jury a greater understanding of the scene and how it related to evidence presented at the trial. The prosecution objected to the idea, writing in their response that the trip was just a waste of time and resources. The prosecutor was arguing that they're going to introduce all types of exhibits showing the layout, maps, drone footage, so there would be no issue that could not be resolved in a courtroom. Like I said, ultimately it was a moot issue because the defense withdrew their motion. Now, like I said, I've seen this a couple times now. I mean, 30 years of practice doing criminal defense, never done a site visit with a jury. We requested it once in a civil case years ago. It was an airplane accident case, and it was nearby the courthouse. And so we thought, hey, let's take him out there. The judge nixed that idea rather quickly, saying, we've got video, we've got photos, we've got measurements, we've got experts, we don't need to go. But it apparently is quite common, apparently more on the East Coast, as we saw in the Murdoch case. Anyway, not an issue. Anyway, the judge had another matter to consider, and that was a motion from the state to prohibit the pair of the composite sketches from the being used in trial. As you may recall, the Indiana State Police released sketches 2 years apart, with the first being revealed to the public back in July of 2017 and the second back in April of 2019, and both have become inextricably linked to this particular case. Now, these were based upon recollection of witnesses in the area, and for years, people attempted to find the various suspects based upon these sketches. While the first sketch featured a man in a hat and a hooded sweatshirt, while the second sketch showed a man who was quite young. Anyway, the prosecutors have filed motions seeking to have the sketches excluded from the trial, arguing that they were not used to identify Richard Allen and have no bearing on the case as it relates now. I think that the defense should be allowed to show what investigative work they did, and it should come in. Anyway, the judge is reserving ruling on that as of yet. Probably going to be a game time decision based upon how the potential sketches would be used by which party and what witness and what relevance it might be. But the judge also ruled that correctional officers and inmates are going to be allowed to testify about Richard Allen's behavior and comments that he made while he was in custody. And she took another motion under advisement regarding the expert defense witness planned to call to discredit ballistic analysis central to the state's case. That's expert testimony. It should come in. I'm not sure why the issue is on that, why the judge would even consider not allowing that witness to testify. Like I said, the opening statements should be ongoing as I'm filming this video. If only we had video, Judge Gall, we could see if both sides were getting a fair trial. Maybe next time. Next, a search for a missing mom ends at a Texas landfill. So authorities in Texas have said that they have found no evidence that tied the missing mom from Olmus Park, Suzanne Clark Simpson, after 4 days of searching a southeast Bexar County landfill. So the Department of Public Safety and the Texas Rangers and the Olmus Park Police Department said that they stopped the search on Thursday. Now, Monday, crews started the process of combing through the landfill in hopes of finding any trace of Susan. The mother of 4 and a realtor has been missing since October 6th, and the search hadn't testified in recent days as law enforcement focused on that particular landfill. Now, on October 10th, information was gathered during the investigation that led law enforcement officers to conduct a search for Ms. Simpson at the landfill. But after the extensive search and digging and sifting through the municipal solid waste, no evidence was found. Now, the missing woman's husband, Brad Simpson, is still being held in the Bexar County Jail on a bond of $2 million after being arrested there in Kendall County last weekend on charges of family violence and unlawful restraint. He is also being questioned in regards to the disappearance of his wife, but he has clammed up since he's retained an attorney. Now, Brad Simpson is also facing a federal felony charge for illegally owning a firearm. Turns out when they were doing a search warrant of the house, police discovered a short-barreled rifle that was not registered to Brad Simpson in that particular home. Rifle, not a big deal. Cutting off barrels, not extending. I think it's 12 inches. It's a problem. Anyway, Mr. Simpson, he's going to clam up, and we'll see if they can find his wife. Obviously, the old adage goes, no face, no case, right? No body, no case. We've seen that before. In the Morphew matter, for example, it gets a little more difficult without a body. Then you got to be able to prove who did it. Obviously, Mr. Simpson's entitled to presumption of innocence, but he was more than likely one of the last people to be seen with his wife. That's usually the way it works out, isn't it, ladies and gentlemen? Next, let's talk about some of the pending motions in the Brian Kohberger matter. So as I was doing show prep today, I was looking at the records in the Brian Kohberger matter. And something that was interesting, and I think this is worth noting, that we never saw this in the Lori Vallow case or the Chad Daybell case. And Brian Kohberger should thank his lucky stars that he is getting the defense in this particular case that he is getting. And because normally in a capital case where they're seeking the death penalty, there's lots of motions practice in regards to the constitutionality of the death penalty, the aggravating factors, etc. They attack everything. And that is what the defense has done in this particular case. All right. And so let me just give you an example of it. The prosecution has filed their objections to their defense motions to strike the felony murder aggravator, the response to the motion to strike future dangerous aggravator, a motion to strike the multiple victims aggravator, and their motion to strike the notice of intent to seek the death penalty, citing a failure to present sufficient aggravators to the grand jury. That was some of the issues we talked about the other day. But when I went through these motions, man, this is really good work on both sides. Now, do I think the defense is going to prevail on any of these? No. For example, one of the motions is to strike the notice of intent to seek the death penalty under vagueness. Motion to strike the intent to seek the death penalty on the contemporary standards of decency, right? The changing standards of decency that early litigation and court opinions going back to the 70s when the death penalty was briefly ruled unconstitutional, and then it was ruled later that it was constitutional. So it's very, very good work. Now, the prosecution, based upon some of those challenges, did file an amended notice pursuant to the Idaho Code as it related to the aggravators. And the aggravators that they are proceeding on in the case of the state of Idaho versus Brian Kohberger are that, one, at the time of the murder was committed, the defendant also committed another murder. Makes sense. He either committed all 4 murders or none at all. Next, the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. Obviously, that's something the jury will consider when they see the crime scene photos, right? If you've ever seen somebody stabbed, it can be pretty heinous, atrocious, and even cruel, manifesting exceptional depravity. Next, that the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. Clearly, Mr. Kohberger is charged with 4 counts of murder, and if one could be convicted of that, if he is, that would show a disregard for human life, no doubt. And then finally, that the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. Odds are, ladies and gentlemen, if you're found guilty of committing 4 murders, there's probably a pretty good indication that, past performance is indicative of future results. You're probably going to do it again as well. And what that motions practice does is it helps both sides flush out their case. That's why oftentimes dispositions are reached in cases as you get closer to trial, because everybody's had a chance to look at it. And that's the beautiful thing about the adversarial system. Hey, the state originally had 5 aggravators. Now they amend it based upon some of the motions practice, and they say we're only going to go with 4. That's why they filed the motion to amend. So what I want to say about the Kohberger case is whether you think that he is guilty or innocent, has been wrongfully accused, Brian Kohberger is entitled to the presumption of innocence, and he is entitled to an effective representation during his case at all critical stages of the proceedings. And what I'm telling you is he is getting it. And based upon the motions, the action that has been taken by these attorneys is so starkly different from what we saw from the Lori Vallow and the Chad Daybell case, also in Idaho. Totally different worlds, ladies and gentlemen. And that's what good lawyering is all about. Next, a father and son are indicted for the Georgia high school shooting. That's right. The Georgia grand jury has indicted both a father and son on murder charges in the mass shooting of the Appalachia High School in Winder, Georgia. Now, the Barrow County grand jury met in Winder and indicted 14-year-old Colt Gray on Thursday on a total of 55 counts, including 4 counts of malice murder, 4 counts of felony murder, plus aggravated assault and cruelty to children. Now, his father, Colin Gray, faces 29 counts, including second-degree murder, involuntary manslaughter, and reckless conduct. Now, both are scheduled to appear for an arraignment on November 21st of this year, and they can then formally enter a plea on that case. Now, Colin Gray is being held at the Barrow County Jail, while Colt Gray is charged as an adult, but he's still being held at a juvenile detention facility in Gainesville, Georgia. Now, neither party has sought to be released on bail because it would be so high, more than likely, that they're not going anywhere. Anyway, what we do know so far as was from the preliminary hearing was investigators testified during a preliminary hearing for Colin Gray that Colt Gray carried a semi-automatic assault-style rifle on the school bus that morning, with the barrel sticking out of the book bag wrapped up in a poster board. They said the boy left the second period class and emerged from a bathroom with the rifle before shooting people in the classroom as well as in the hallways. Now, the shooting resulted in the deaths of a teacher, Richard Aspinall, and Christina Irmi, and students Mason Sherahorn, Christina Anguillo, who are both 14 years old, and another teacher, and 8 more students were wounded, 7 of them hit by gunfire. Now, it is alleged that the young teenager carefully plotted the shooting at the 1,900 student high school northeast of Atlanta, Georgia. And the Georgia Bureau of Investigation agents testified that the boy left the notebook in his classroom with a step-by-step handwritten instruction to prepare for the shooting. It included a diagram of his second period classroom and his estimate that he could kill as many as 26 people and wound as many as 13 others, writing that he'd be surprised if he made it this far. Anyway, so Colt and Colin Gray were interviewed about an online threat linked to Colt Gray back in May of 2023, and now Colt Gray denied making the threat at the time, and he enrolled as a freshman at the Appalachia High School after the academic year began, and then skipped multiple days of school. Investigators said that he had a severe anxiety attack on August 14th, and the counselor said he reported having suicidal thoughts and rocked and shook uncontrollably while he was in the counselor's office. Now, Colt's mother, a woman by the name of Marcy Gray, who lived separately from the child and the ex-husband, told investigators that she had argued with Colin Gray, asking him to secure his guns and restrict Colt's access to those guns back in August. Instead, he bought the boy ammunition, a gun sight, and other shooting accessories. Now, after Colt Gray asked his mother to put him in a mental asylum, the family arranged to take him on August 31st to a mental health treatment center in Athens, Georgia, and offer inpatient treatment. But the plan fell apart when his parents argued about Colt's access to guns the day before his father said he didn't have gas money. Anyway, Colin Gray's indictment is the latest example of prosecutors trying to hold parents responsible for their children's actions in school shootings. As you may recall, we've talked about the case in Michigan involving Jennifer and James Crumley, the first parents to be convicted in a mass shooting, and they were sentenced to 10 years in prison for not securing a firearm at home and acting indifferent to signs that their son's deteriorating mental health before he killed 4 students back in 2021. It's also alleged that the dad in this particular case had knowledge of Colt's obsession with school shooters. He had knowledge of Colt's deteriorating mental state, and he provided the firearm and ammunition that Colt used in this shooting. Now, ladies and gentlemen, slippery slope. I told you that. And look, it is all coming true, right? The Crumley case, I said it was a unique, novel prosecution, and it went forward. And like I said, if the parents are down there saying, hey, today's the big day, you got your gun, you got everything you need for the big school shooting, yes, they would be complicit, all right? Because we charge people for knowingly, intentionally doing something in criminal law. When you get into negligence, right? You were negligent. Oh, you should have locked it up. Oh, you should have done this things a little differently. We're reducing the knowledge element. And the Supreme Court, I think, is getting close to ruling on some of these issues because that's not what criminal law was meant to be. Negligence is a much lower standard. What a reasonable person would be? No, you're charged on crimes of what you knowingly or intentionally did, ladies and gentlemen. So, I don't like these unique, novel theories. And frankly, if this is going to be the new standard, why stop it? Why stop it at school shootings? How about somebody shoplifts? Charge the parents. Why didn't they give them enough money? They knew they didn't have money. They were going to steal it. Maybe they're hanging out with the wrong kids. Charge the parents, ladies and gentlemen. Why stop there? They steal a car, charge the parents. It's a slippery slope, ladies and gentlemen. And I know it makes everybody feel good. And everyone's going to say, oh, Scott, but he knew. Did he say go down and shoot the kids at the school? No. Is he negligent? Probably. Okay, go sue them for wrongful death in a civil matter, which is a negligence standard. Negligence shouldn't be in the criminal process, ladies and gentlemen. Just my humble opinion. Just saying. Next, another celebrity arrested for DUI. Who is it? I know you're all waiting with bated breath. Yes, Jay Cutler, right? The former football player, and he had a show with his wife where they did something, I don't know. Well, he's been arrested for DUI and gun possession in Tennessee. Now, the former football star was jailed Thursday after he was stopped while allegedly driving intoxicated with 2 firearms, including a loaded pistol, according to the police reports. Now, Cutler was arrested after a minor traffic accident in downtown Franklin, Tennessee, where it's alleged that he may have rear-ended another car. But when the police arrived, guess what? They noticed a strong odor of an unknown alcoholic beverage on the breath of Mr. Jay Cutler. When he was speaking to police officers, he had reports of bloodshot, watery eyes. And Mr. Cutler then refused a sobriety test and was taken to a hospital. But guess what? They got a warrant, and they took a blood sample. Now, Mr. Cutler is also accused of failing to exercise due care and violation of the implied consent law, which says that if you operate a motor vehicle, you expressly consent to give your breath or blood if the officer has reasonable belief to believe that you are under the influence of drugs or alcohol or a combination of both, ladies and gentlemen. Mr. Cutler was released from the Williamson County Jail later that afternoon after posting a $5,000 bond. That's not going to help with the old ex-wife that apparently I think I saw the other day. Because, I keep up on all this stuff, ladies and gentlemen. You would not believe the amount of information I have to read to keep up with pop culture to make sure that I bring you the most relevant stories out there as it relates to law and crime, even when it involves celebrities. Next, Karen Reed. Okay, Karen Reed, I know we've talked about her all the time, right? Well, guess what? She's doing an interview with Dateline. That's right, Dateline, the NBC news program, soft news program. It's interesting, though, if you think about it, why didn't she testify at her trial? But now she's doing this interview. Now, I understand she has a right not to testify at trial. I get it. But why tell her story to Dateline NBC? Is it because it's going to be a softball puff piece, perhaps? Has NBC been asked to not ask the tough questions, to let her tell her side of the story? Possibly. I just think it's interesting. Why didn't she do that? Why? Because I bet, now we haven't seen this is going to air this weekend, but my guess is it's going to be a total puff piece. There's not going to be any hard-hitting questions at all. The interviewer is not going to know what questions to ask, like how much had they had to drink that night, really. I mean, as we all know, Karen Reed's trial ended in a mistrial back in July. And it all revolves around the night of January 29th of 2022, where Karen Reed was dating her then police officer boyfriend, Mr. O'Keefe. And apparently there was some late night partying, some drinking. And now Mr. O'Keefe is dead. Karen Reed is accused of basically hitting Mr. O'Keefe and killing him and letting him die in the frozen tundra of Massachusetts in the wintertime. Now, the medical examiner ruled the cause of death a blunt impact injuries of the head and also hypothermia, but could not determine whether the manner of death was a homicide or just an accident. And like I said, Reed was charged with second-degree murder, manslaughter while operating under the influence of alcohol and leaving the scene of an injury resulting in death. And obviously she's pled not guilty. Now, during this interview, Reed also talks about the moments that she found O'Keefe lying motionless in the snow. She said help came very quickly, she states, and maybe within just 15 minutes. She didn't know who had arrived, but there was a ladder truck, but they were there in a pretty short order, she was going to tell the reporter. And then Reed was also taken to the hospital that morning, as she recalls, and she was put under a psychiatric watch just two little vestibules down from where they were working on John's body, she says. Then eventually, just before noon, her father came in and told her that, guess what? That John was gone. She nearly collapsed to the floor, she's going to tell the reporter in apparently dramatic fashion. Anyway, the special is also going to have an interview with Miss Reed's attorney, Alan Jackson, who's going to give a behind-the-scenes look into the defense strategy and detailing their theory that Miss Reed was framed by the police. Now, this is going to air Friday, October 18th at 9 p.m. I will try to watch it, even though I will be out of state, probably partaking in lots of fun, but I'm still going to try to watch it. You got to be careful when you use the media like this, but I think you need to ask yourself a question when considering this, and I know I will be, is how tough are the questions going to be? Probably a total puff piece. And then the question then becomes, why didn't she tell this story at trial if this is the way it came out? Why, and is she going to do it? Again, and certainly she has a right not to testify at her trial, but I'm a firm believer that if you're going to exercise your right to remain silent, you do it all the time. All the time. Next, this day in history, on October 18th, 1945, the Nuremberg trials of the Nazi war criminals began. The lead prosecutor was a guy by the name of Robert H. Jackson. And finally today, our dumb criminal of the day. Please meet Daniel Reyes. He is from Pueblo, Colorado, and he is facing felony charges of attempting to influence a public official after admitting to police he lied about a teenage girl that he claimed was kidnapped in his truck when it was stolen. That's right. Apparently the story fell apart rather quickly when he admitted that he lied because he wanted the police to respond much faster, and they figured if there was a kidnapped child in the car that the police would take a greater interest in the case. Anyway, Mr. Reyes stated that his niece was in the vehicle while he was in Colorado while visiting down there in Pueblo, Colorado. But when the police put out this information, they issued an Amber Alert, and they also put it on social media. The girl that was in the photo, their parents called the police and said the girl is here safe, and they haven't seen this Daniel Reyes guy in years. Kind of severed ties with the guy. So like I said, Mr. Reyes made it all up, and he just wanted a faster response from the police. He's being charged with attempt to influence a public official, a Class 4 felony. Guess what? Mr. Reyes has a lengthy criminal history, including assaults that go back several decades. Anyway, he's now on a $10,000 PR bond. He's back in court on October 24th. Now, I get it. Everybody lies to the police. Usually the first version to the police is not the truth. It's just the way it is. But don't go and lie to the police like that to get it. That is attempting to influence a public official, ladies and gentlemen, even if it doesn't work out. But here he actually succeeded. So it wasn't just attempting to influence a public official. He did it. Mr. Reyes, you are a dumb criminal of the day. Congratulations. But hey, if you need an attorney, we can make it to Pueblo rather quickly. Call me. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. Have a wonderful weekend, and remember, the Constitution matters.